A very good afternoon. I am Prasenjit Kundu, Assistant Professor of Law, Dr. Lohiya National Law University. On behalf of Dr. Lohiya National Law University, and also on behalf of Society of Excellence in Arbitration, Dr. Lohiya National Law University, allow me to extend a warm welcome to all of you on this national webinar on contemporary issues in arbitration law, anti-arbitration injunction. Looking at this topic, it reminds me a remark of Redfern and Hunter, the two internationally renowned jurists in international commercial arbitration. While dealing with this relation of the national court in international commercial arbitration, Redfern and Hunter commented that the relationship between this national court and the arbitral tribunal swings between forced cohabitation and true partnership. The success of the commercial arbitration lies in fact in achieving considerable degree of independence from the national court. But at the same time, it is this national court which alone does have this power to rescue this commercial arbitration when one of the parties would try to sabotage this arbitration. Therefore, we understand that the national court must play its role very cautiously so that its assistance does not turn into unwarranted judicial intervention. And therefore, the entire jurisprudence of the power of the national court to grant anti-arbitration injunction is to be viewed from this philosophy, from the philosophy which is underlying, which is there in the quotation which just now I quoted. Therefore, there are some questions which come before us. First question, under what circumstances the national court shall grant this anti-arbitration injunction? What are the qualifying circumstances? Whether the grant of this anti-arbitration injunction would be something which would be, against the interest of the party autonomy, which is one of the, cardinal principles of international commercial arbitration. These are some of the questions. Obviously, we understand need elucidation, and for that we have esteemed speakers with us. Now, the entire outline of this program, as well as setting the tone of this deliberation, shall be made by Mr. Abishek Dwivedi. Now, Abishek Dwivedi is practicing law at Allahabad High Court, Lucknow bench, and specialized in arbitration, contract, and white-collar crimes. Before starting independently, Abishek worked with Amarchand Mangaldas, Mumbai, and also worked in the dispute resolution team of Economic Law Practice, Mumbai. I extend my cordial welcome to Mr. Dwivedi. Moving on further, ladies and gentlemen, we are fortunate to have with us, and it is indeed a great pleasure for me to introduce the two eminent personalities who have put a mark in the emerging field of international commercial arbitration. We have with us Mr. Surjendu Sankar Das. Mr. Das is practicing law in Delhi as an advocate on record of Supreme Court of India. He is a former dispute resolution partner of Amarchand Mangaldas and Company, New Delhi. Mr. Das has significant experience in handling as an advocate in complex trials, appellate matters, writ matters, arbitration, and enforcement proceedings. He is well known for successful handling of complex issues of domestic and international arbitration, and also in the enforcement proceedings. I extend my cordial welcome to Mr. Das. We also have with us Mr. Lomesh Kiran Nidumuri. Mr. Lomesh is an experienced litigator with over a decade and a half of experience in handling civil and commercial disputes, especially international as well as domestic arbitration. He completed his Masters of Law from New York School of Law and is currently a partner at IndusLaw. He has also worked at the Office of Standing Counsel for the Government of India, New Delhi, representing the Government of India on a wide range of disputes. I extend my cordial welcome to Mr. Lomesh Kiran Nidumuri. Now I request Abishek Dwivedi to take over this session and proceed further.
Good afternoon, everyone. Thank you so much, Dr. Kundu, for this wonderful introduction. It is a pleasure to have this session, moderate this session with two seasoned and experienced arbitration practitioners. Dr. Kundu has already introduced them, so I'll just move directly to the event and the topic which we are going to discuss. As I understand that this will be a full lecture series, and today we have selected the topic of anti-arbitration injunction in domestic as well as international developments, and we'll discuss these two in two separate segments. Now, as you all are aware that recently, due to many judgments by by Delhi High Court as well as the Malaysian courts and UK courts, the topic has gained quite a recent discussion. It has become a topic of discussion inside the court as well as outside the court. Now, what we will be doing in this entire event today is that it will be divided into three segments. Firstly, Mr. Surjendu will speak on the domestic aspects of this topic of anti-arbitration injunctions, while Lomesh will speak on the international aspects of this topic. These segments will be divided into 20 minutes, which will be followed by a question and answer sessions. And I clearly state that, and please note that you'll have to post your questions, whatever you want to ask the panelists, in the comments in the live YouTube stream, and I will select I will try to cover as many questions as I can due to our limited time. Now, without any further delay, Surjendu, I would request you to take the lead. Specifically, I would request you to briefly explain the nature, scope, and the elements of anti-arbitration injunctions, while also touching briefly upon the recent Bina Modi judgment by the Delhi High Court. All yours, Surjendu. Sorry.
Is the concept of anti-suit injunction. Injunction which lies in specific relief act, and it has been dealt in several decisions. And in terms of anti-suit injunctions, in 2003, Supreme Court had laid down the law in Modi entertainment decision, and that has been widely used all over. In fact, to some extent, some of the high courts and Supreme Court, they rely on Modi entertainment while discussing about anti-arbitration injunction. What is anti-suit injunction is that a party is injuncting the other party to institute or prosecute a suit in other jurisdiction. So obviously the question comes, the natural jurisdiction, for example, the contract is executed, performed in India, and second jurisdiction would be what the parties have chosen or choice of parties. That may be outside India as well. For example, parties have chosen London as their choice of jurisdiction. Here the question comes, if a party wants to injunct the other side to institute or prosecute a suit abroad, he will have to file a suit in India. That's called anti-suit injunction. What the Supreme Court has laid down in Modi entertainment is that you should respect the choice of the parties. So therefore, once the anti-suit injunction is granted, so there's a breach of agreement, there's a breach component comes, and court should not indulge into that breach. In the sense, the court should not allow the parties to commit the breach by injuncting the other side to initiate or prosecute proceedings abroad. Having said so, it laid down two basic principles on what count an injunction can be granted. First, it said that though you have chosen a jurisdiction, particular jurisdiction, if the proceedings are oppressive or vexatious, or if it is forum non-convenience, then a particular jurisdiction, or say in Indian jurisdiction, Indian court, will have to power to injunct the other side to stay the proceedings abroad in foreign jurisdiction. So that was 2003. Thereafter, in 2011, I think there's a Delhi High Court decision which has followed Modi entertainment, and they have injuncted a party to initiate some proceedings abroad in UK courts. So this is the background of anti-suit injunction. Now coming to the primary topic of today's discussion, anti-arbitration injunction. Again, it's a substrata of injunction only. If you look at prospectively, is falling within a specific relief act. When you try to injunct other side, you have to rely on specific relief act. But very interestingly, and more importantly, in McDonald's judgment in 2016, Delhi High Court said that while granting anti-arbitration injunctions, the principles governing the injunction in anti-suit injunction will not be followed in arbitration because of two reasons. First is that you should respect the principle of party autonomy, and second is competence principle. Now, if we look back under 1940 Act, we had a provision, section 35, which sort of had given the power to the court to grant injunction or to grant stay in arbitration. So, taking help of that provision in 1969, Supreme Court had allowed an injunction, anti-arbitration injunction, to stop a party to proceed with arbitration in Moscow. That was the first injunction, at least his historical perspective I could find. Later on in ONGC versus Western Company, it happened in 1987. Again, Supreme Court of India allowed other side a party to proceed with arbitration in New York. So those are under 1940 Act. So now we have 1996 Act, and of course many things changed. Scope, objective, everything had changed, and there are judgments also to say that the case laws under 1940 Act should not apply to 1996 Act, so on and so forth. So starting from that, the first judgment under 1996 Act, the landmark judgment, I would say, is Cravener. Cravener happened in 2012, but unfortunately, there was no judgment as such. It was a 2-pages order of Supreme Court. It said that in case it relates to, the question relates to the jurisdiction of the court, the jurisdiction under the arbitration agreement. Of course, it has to be determined by the tribunal under section 16. So the Supreme Court did not allow the parties to injunct the arbitration, but it said that since it involves the objection as regards the validity of the arbitration agreement, the question can be determined by the tribunal as a preliminary issue before the arbitral tribunal. So that was the 2012 decision, and this judgment has been relied on many other decisions. Now, most important decision in anti-arbitration perspective, what I feel was laid down in 2014 by the Supreme Court in World Sports Group judgment. It was very categorical. It said that for the purpose of anti-arbitration injunction, the principle you should follow is provided under section 45 of part 2 and section 8 under part 1. What does it mean? It means that a court cannot injunct to proceed with arbitration unless it finds the arbitration agreement is incapable of being performed, it is inoperative, or null and void. These are 3 parameters which is provided under section 45. So if any of these 3 principles are met, then the court in India has power to injunct an arbitration proceeding. Now, the question remains, what is the scope or meaning of these 3 principles? So I'll briefly touch upon what you mean by inoperative. So I'll give an example. So if in a dispute, there's a previous arbitration award which has been passed, or court has taken a decision, some civil suit was filed, court has taken a decision, and those operate as res judicata, then it amounts to inoperative. The arbitration agreement is inoperative. There's another example which has been given by the Supreme Court. Actually, Supreme Court has relied on a different definition principle laid down by Redfern Hunter, then Vandenberg. So, keeping all these principles in mind, it also said that if the time limit is framed to initiate arbitration and that is not followed by a party, then again it amounts to inoperative. So therefore, the court has the power to injunct the arbitration if it is invoked beyond the time frame. So far as incapable of being performed, there are two examples given in the judgment. One is that for some reason the arbitral tribunal cannot be set in motion, it cannot be established, or the arbitration agreement is too vague. Then you can say that the arbitration agreement is incapable of being performed. And the last question is how it is null and void. So one has to establish for that purpose that because of the arbitration agreement is invalid because of lack of consent, maybe because of duress, fraud, and other issues. So if any of these three principles are met, then Indian court has the power to injunct arbitration by an anti-arbitration injunction. Now, most importantly, these three principles have to be applied so far as the arbitration agreement, not the main contract. In my experience, I have seen that when the parties approaching to the court seeking anti-arbitration injunction, sometimes they confuse between what is null and void, inoperative, or incapable of being performed, where the main contract and not the arbitration agreement. So the test is that you have to satisfy that any of these three criteria are met where the arbitration agreement, not the main contract, because of the principle of severability. Now, next landmark decision which comes is McDonald's judgment. McDonald's judgment is 2016. Again, it's a division bench judgment which has set aside, which overturned the judgment of the single judge, and it said that no anti-arbitration injunction can be granted in the given facts and circumstances. And quite interestingly, what happened? This judgment does not take into consideration Cravener 2012. So in subsequent decision, is in Veena Modi, that Delhi High Court says that this McDonald's decision is per incurrem where the Cravener judgment. So having said so, I would say that McDonald's decision, the main principle what has been laid by the Delhi High Court is that it again reiterates and to some extent reaffirms that you cannot apply the principle of anti-suit injunction in anti-arbitration injunction. That's the first and foremost thing. And here the main question was that some NCLT, or earlier it was CLB, the CLB proceedings was said to be, if in view of this NCLT or CLB proceeding, the arbitration becomes proceeding vexatious or oppressive. Court held that no, you can't say so because you have chosen arbitration as a mode of dispute resolution. So nothing doing, and the anti-arbitration injunction relief was declined. Now, there was a Vodafone decision also in 2018. Delhi High Court had initially granted stay in a treaty arbitration, but thereafter had overturned the single judge judgment. Now, another important decision, what I feel is that Chatterjee Petrochemicals in 2014 by Supreme Court. The importance of this decision is that now there's a trend of applying Section 5, which says that courts will have minimal intervention. Courts have minimal intervention, it's only supervisory role. So this Section 5 has to be applied for the purpose of anti-arbitration injunction. Now, what Chatterjee Petrochemicals and in fact, I think McDonald's also say the same thing, is that Section 5, look at the provision, it's falling within Part 1. So once you're applying Section 45, which is Part 2, there, in case of international commercial arbitration, you cannot apply Section 5. So this observation was held not valid. Sorry, this argument was held not valid. And Supreme Court and later on High Court said that Section 5 principle equally applies to Section 45 as well. So that's the importance of Chatterjee Petrochemicals, I find. Now, another important aspect, as I said in the beginning, that genesis of anti-arbitration injunction lies with Specific Relief Act. So here, the Section 41H is important, which says that if you have equally efficacious relief available through some other mode, then Indian court will not grant injunction. That principle has been applied throughout including different high courts and in Delhi High Court as well. So the principle is that the parties have consciously chosen an alternative remedy through arbitration. Having chosen that, you can't say that arbitration is either vexatious, oppressive, or is forum non-convenience. Sometimes people say that no, this is costly, London arbitration is very costly. That can't be the case, because having chosen a foreign seated arbitration, you can't later on say that no, that is oppressive. That's a very important aspect. Now, another crucial factor which is considered in couple of Delhi High Court decisions is that that a suit, the principle of CPCA will be applicable in arbitrations. And what happened in a suit in 711 Order 7 Rule 11, you say that if the suit is barred by any law, then plaintiff has to be returned. It can be, suit is not maintainable. So when you say that suit is barred by law, Section 5 comes into picture. Section 5 as well as Section 16. So in couple of Delhi High Court decisions, they say that why it's barred by Section 5? Because court has minimal role to play. It will not intervene. And Section 16 allows the arbitral tribunal to decide the jurisdiction, its own jurisdiction, including the validity, existence of the arbitration agreement. So the principle under Order 7, Rule 11, I think is D, was applied to say that Section 5, Section 16 should be applicable. And in such a case, when you have arbitration clause, you cannot injunct the arbitration in a civil suit. Now, Bina Modi and Lolit Modi is 2020 judgment. Now, what happened in Bina Modi judgment is that I'll say it doesn't lay down any new law. It reiterates the previous decisions, including McDonald's decision, and it refuses to grant any injunction on several counts, because one question was that is a trust dispute. So you cannot do arbitration, but there's observation that this trust was not registered in India, so Indian Trust Act does not apply. So there's no question of Indian law applicability. So this kind of questions were decided, and the injunction was refused. And very recently, I think it's last week, there's a Calcutta High Court decision where the Calcutta High Court has injuncted to proceed with an arbitration for 4 weeks, because it has some complex facts, and it said that I'll consider during lockdown. During lockdown, parties should file their pleadings, and will in appropriate stage will decide. But in the meantime, you should not proceed with the arbitration. So this is the historical background, I would say, that how the anti-arbitration injunction has developed. And having said so, what is the observation is that court is very conservative to grant an injunction in an arbitration. So with that, I think I'm conscious of the time. It's already 3:30. So I'll hand over to Abishek to take it forward.
Hi, thank you, Surjendu. Thank you so much. That was an enriching session, and I'll be following up on that with lots of questions which I've received in the comment section as well as on my WhatsApp. But let's move on to the international developments as of now. We have recently seen a lot of new cases on anti-arbitration injunctions on international level in UK courts as well as in Malaysian courts, specifically the two rulings which I understand Lomesh will be discussing on the Malaysian aspects, in the sense the interference of a third party seeking an arbitration injunction, anti-arbitration injunction, as well as the usage of sovereign immunity by government undertakings or the countries themselves as a tool to achieve or get an anti-arbitration injunction. How does this entire scenario changes in light of these judgments? So Lomesh, I'll transfer this to you, and I'll follow up on this in the question answer session, specifically on the issue of sovereign immunity. Please, all yours.
Thank you so much, Abishek, for this, and thank you, Surjendu, for detailing the Indian position quite lucidly. Usually, when you're asked to speak on international perspective of something, it usually means good news. You have the Indian perspective, there's a lot of India bashing. The foreign perspective is usually brought in to sort of give a breath of fresh air in that sense, to give a new perspective to it and to say that these are the significant major developments that are happening in the international scenario. So at the outset, let me tell the viewers that I have some really bad news. Unfortunately, in fact, it's good news for India in that sense, but bad news insofar as international development. International developments, unfortunately, don't seem to keep up with the pace that Indian legal developments have taken, particularly in the recent past. If you look at the Bina Modi judgment, Bina Modi judgment was very significant in that sense. Bina Modi judgment reminds me of a movie in that sense, where you have a hero who's sitting in a boardroom and the whole boardroom is discussing certain things and everybody's going off on a tangent, and suddenly the hero raises his hand and says, why don't we do it in this particular way? Why have you not thought of this particular thing? Bina Modi judgment is something like that. The reason being, as Surjendu also mentioned, there was a 2012 Supreme Court judgment of full bench, 3-judge bench in Quana cementation case, which essentially said that if there is any preliminary jurisdiction issue, that has to be decided by the arbitral tribunal itself. So therefore, on that ground, any ground taken in an anti-arbitration injunction suit would not be maintainable. The Indian court seems to have taken a completely extreme view in that sense. I will be dealing with what the position in UK and Malaysian court is, where the international development appears to be a lot more conservative and a lot more rigid in that sense, because what the international development says is that unless and until it is, as the words that were used earlier was, unless and until the arbitration proceedings itself are oppressive, or if it is void, or if it is null, or if it is incapable of being performed, only in those situations the anti-arbitration injunction will be granted. But the Delhi High Court has sort of set the cat among the pigeons, so to speak, to say that all the developments in law that have taken place from 2012 all the way up to 2020, most of the judgments do not appear to have taken note of the Quanar Supreme Court judgment. And in fact, Delhi High Court in Bina Modi judgment goes to the extent of saying that even the McDonald's judgment of the division bench of the Delhi High Court appears to be per incuriam, because they have not even taken into account the ruling of the Quanar judgment. Now, coming to the international principles, let me first go to the UK principles first before I get into the Malaysian sovereign immunity and the other tests that you spoke about. Insofar as the UK judgments are concerned, I would like to rely on this judgment of Claxton Engineering, which is a Queen's Bench decision of the Commercial Court. Essentially, what happened was there was an arbitration agreement between an English party and a Hungarian party. And the Hungarian party went before the Hungarian Chamber of Commerce and initiated the arbitration proceedings. An anti-arbitration injunction suit came to be filed in the English courts on the ground that the agreement provided for an exclusive jurisdiction clause to the English courts to decide the dispute, notwithstanding the fact that there was also an arbitration clause in the matter. So ultimately, what the English courts did is they said that there were a lot of arguments taken saying that you cannot go into this issue, all these issues should be taken in by the arbitral tribunal itself. But ultimately, what the court held is that in view of the fact that the exclusive jurisdiction was given to the English courts, that would sort of trump all the other jurisdictions of the other courts, including any arbitrations that are initiated in a foreign court, and granted an injunction restraining the Hungarian Chamber of Commerce from proceeding with the arbitration. So that seems to be a very interesting development in terms of how UK courts have actually granted an anti-arbitration injunction, provided the contract itself required that the contract would be governed exclusively by the English courts in that sense. The second judgment that I would like to rely on is the judgment of Excalibur Ventures versus Texas Keystone, again a Queen's bench decision of the Commercial Court, which was rendered on 28/6/2011. This was an interesting case where the court, though it said that anti-arbitration injunction can be granted only in exceptional circumstances, but considering the facts of the case, it actually proceeded to grant an anti-arbitration injunction. The reason was this. Initially, the claimant had filed certain actions before the English court itself. Notwithstanding the fact that those proceedings are pending in the English courts, the same party went ahead and filed certain arbitration proceedings before the New York Arbitration Center. And they, not only that, what they also did was they roped in a lot of non-signatories to the arbitration agreement, particularly the parties who were in Gulf, also into the ambit of the arbitration proceedings itself. So naturally, the Gulf parties went to the UK court and said there should be an anti-arbitration injunction that should be granted as against this party, because the proceedings itself are oppressive, they're vexatious, and they infringe upon my rights. And the way they made out the ground was this. There were a couple of interesting arguments which were made. The first thing was that the claimants, the plaintiff in this case, was able to successfully argue that the law that was applicable insofar as the dispute was concerned, they were inconsistent in terms of the same party had used English and New York law for the English action, whereas they used only the New York law insofar as a New York arbitration. So that is one thing that played on the mind of the court, to say that you can't be forum shopping in this manner, and you can't be applying different laws to different disputes and then make a party run from pillar to post. So this is one of the factors that weighed. The second factor that played in the mind of the English courts was that the English court categorically held that they retain the ability to determine the question of jurisdiction. Now, this is a very important aspect. Now, if you contradict with this, with the Indian judgment of Bina Modi case, what Bina Modi case essentially said is, if there is any kind of a jurisdictional issue that would be raised as part of your anti-arbitration injunction, the natural remedy is to actually go before the arbitrator under section 16 of the Arbitration Act and raise all these contentions. But the English courts take a slightly different path in this sense, primarily because the wording of the section itself is very different under the English Arbitration Act and the Indian Arbitration Act in that sense. I would sort of make reference to the most important difference to see how the UNCITRAL model law has actually been adopted into the local domestic laws. Now, what the UNCITRAL model law says is, Article 5, extent of court intervention in matters governed by this law, no court shall intervene except where so provided in this law. The same thing has been adopted in our section 5, which Surjendu also took the audience through, where section 5 says that no judicial authority shall intervene except where so provided under this act. Whereas the UK Arbitration Act is very differently worded. If you look at section 1C of the Arbitration Act of 1996, what it says is, in matters governed by this part, the court should not interfere except as provided in this part. Now, there is a material difference between the word shall and should. And that appears to sort of play in the mind of the English court in saying that because the word is not shall, we have the jurisdiction in that sense to determine as to whether or not any case has been made out where the proceedings are either vexatious or they're frivolous, or they're, the arbitration agreement itself is null and void or incapable of being performed. The other aspect that played on the court's mind in this case, and even in the Sana Sabha case, which is another landmark case of 2019, in these two cases, the predominant sort of force that played in the mind of the court was the fact that Section 37 of the Senior Courts Act of the English courts itself, which is akin to Order 39, Rule 1 and 2 of the CPC in the Indian courts, what the courts have consistently held in the English courts is that by applying the principles of Section 37 of the Senior Courts Act, it is very much possible for an English court to say that, notwithstanding the fact that the UNCITRAL model law may actually say that all these issues have to be actually looked into by the arbitral tribunal, notwithstanding that, English court would still retain the jurisdiction to make a prima facie finding as to whether or not any of these tests are actually made out in grant of an anti-arbitration injunction. Though, of course, the courts have made it categorically clear that this would only be in exceptional circumstances, but that is the approach that has been taken. The next judgment that I would like to rely on is the Sana Sabha case, that is of the 2019 judgment, which I just referred to. As I pointed out, the difference between the word shall and should in para 58 of the judgment was taken between the UNCITRAL model law and the Arbitration Act of the UK, which entitled the UK court to actually look into these questions. Now, in the Sana Sabha case, the dispute predominantly arose from a family settlement, so to speak, where in 2010 the father died and there was some dispute between the siblings, and an arbitration was taken out in Lebanon. And because the arbitration proceedings were taken out in Lebanon, what one of the parties did was they approached the UK courts to say that UK courts would have the jurisdiction to grant an anti-arbitration injunction for the various reasons mentioned in the particular judgment. And the court ultimately made a very detailed and a very interesting judgment. I would say that if you compare the Bina Modi judgment with the English judgment, Bina Modi judgment has taken the law to a next level in that sense, where it gives complete autonomy to the arbitral tribunal itself to decide everything. Whereas the UK court in this case was extremely circumspect to ensure that the English courts are not sort of divested of their own powers to deal with anti-arbitration injunctions, and ultimately an anti-arbitration injunction was granted for a part of the claim and the other part was referred to the arbitration. The next case which I would like to rely on is the case of Ministry of Finance, Malaysian Development Board versus International Petroleum. This is a case which involved the financial irregularities committed by Najib Razak, who was the former Prime Minister of Malaysia, where the fraud apparently, allegedly, the amount is in excess of USD 3.5 billion. So what had essentially happened was there was an arbitration agreement between the parties. There was a first consent award that was passed by the London court, and a suit was filed to have that set aside. So after the consent award was passed, one of the parties went to the English courts and said there is some kind of a fraud or there's some kind of collusion in this particular consent award, and therefore that is vitiated and it needs to be set aside. Just when that action was filed, immediately a second arbitration proceeding was taken out by the parties for a declaratory right stating that the consent award is actually binding on the parties, so to speak. But then the court, again exercising the jurisdiction, held that the pursuit of the second arbitration, I quote unquote, imposes large financial penalty on the claimant, and therefore an anti-arbitration injunction was granted in this particular case. Now, just that is insofar as the UK part is concerned. Now, moving on to Singapore. Now, Singapore has actually taken a slightly more advanced sort of an approach, if I can call it advanced. The reason is it has given more autonomy to the arbitral tribunal itself to determine its own jurisdiction. In a particular case of Malini Ventura versus Knight Capital, which was very beautifully written by Justice Judith Prakash. I would urge the viewers also to read this, a very interesting judgment, wherein there were allegations of also forgery in this particular case, and an anti-arbitration injunction came to be passed in this case also. But the contention taken by one of the parties was that I'm not a signatory to the particular guarantee deed, guaranteeing the personal guarantee deed, guaranteeing the obligation on part of somebody else. The reason being that there were allegations of forgery, etc. But the court actually did a prima facie test, actually looked into the whole fact that whether there was actually forgery, etc., and actually went ahead and passed an anti-suit injunction. Now, coming to the last bit, I believe that I may be running out of time. Just two aspects. One is with regard to the Malaysian court judgment that you referred to and the sovereign immunity test. Now, insofar as I will deal with the sovereign immunity test. Now, insofar as the sovereign immunity test is concerned, this was a judgment of the government of Malaysia versus Nurima Kiran Foran. That is a Malaysian High Court judgment where the federal court, what it essentially said is, if you're a non-party or a non-signatory to an arbitration agreement, and if there are already court proceedings pending, then there is no point having a piecemeal approach of bifurcating certain things to the arbitrator and bifurcating certain things to the court. What it essentially said is, we will have everything go before the court itself, and let us not piecemeal the approach. And the court also held that the Malaysian court, in that sense, would be a proper forum to determine the entire dispute. The reason is the entire cause of action also arose within the courts of Malaysia. I'm not sure how I'm doing in terms of time. I may have exceeded the time. So subject to Abishek, you saying that if I have further time, perhaps.
Please continue for a couple of minutes. I'll let you know when.
Thank you so much. So essentially, insofar as the sovereign immunity test is concerned, that is obviously subject to the United Nations Convention, and the convention is not come into force as of now. It has not been ratified. It is not really in force. And this was a one-off case in this particular case where an injunction seems to have been granted. But of course, going by the articles that have been written, everyone is very excited about the fact that sovereign immunity is being used for the first time ever, etc. But I would take it with a pinch of salt. The reason is the facts of the case were entirely different in this particular matter. The facts of the case where there was a deed of cession insofar as the North Borneo area was concerned in Malaysia. There was an 1878 deed of cession, which was where certain areas of North Borneo was given to one particular party in return for certain royalties. There was a 1939 suit. The 1939 suit held that certain party would get the amounts insofar as those agreement is concerned. Now, subsequently, what happened is one of the parties went and initiated arbitration proceedings, notwithstanding the fact that there was a 1939 suit. In the light of this, what the court said is, first of all, if you read the arbitration agreement, so to speak, in this particular case, it does not read like an arbitration agreement. There is no reference to arbitration anywhere in the dispute resolution clause. That is one. The second reason is the 1939 suit judgment itself makes it very clear. The court says that in the event there are any further differences between the parties, you please come to the Malaysian courts itself. And thirdly, because the cause of action accrued within Malaysia and the other party went to Spain, and Spain, they went and got an order of appointment of an arbitrator, but there was an 1885 protocol in which Spain ceded complete control insofar as this particular area was concerned. So therefore, the court said that, so look, Spain has absolutely no nexus to this because they also have given up their rights insofar as this territory is concerned. So the natural forum for actually going ahead with this a particular dispute would be Malaysian courts. It was on that ground that this whole sovereign immunity thing was taken. But of course, time will tell how this plays out because we'll have to really see how that convention comes into force, etc.
Sure. Fantastic. Thank you so much to both the panelists. And before I move on to the questions, we have 2 or 3 interesting questions, and I'll add a couple of mine also. Before we move to that, Surjendu, is there anything you want to add or you want to clarify or anything you want to add to this to the discussion right now? Or should we move ahead with the question and answers?
Let's move ahead with the questions only because it's timing is short.
Sure. So the first question I have is for you, Surjendu. It's a very basic question. The question is, in light of Bina Modi's judgment, and the statement that under Section 41 of SRA, Section 16 is a good remedy, is the efficacious remedy. What are your opinion on that? Do you think it actually is a remedy under 41 also? Like, will it help?
What I understand, the equal efficacious remedy you're referring to Section 16, right? I couldn't hear it properly.
Yes. Section 16 in light of Section 41 of SRA.
All right. So now, if we are referring to Section 41 of SRA, it talks about that equal efficacious. It's not sort of alternative remedy, but the relief what you're looking for here, you can get it there. So there is a principle of Section 41. If you get it, then you're not entitled for injunction. Now, when relating to particular to Section 16, I will say that you must also consider Section 5 as well as Section 34, like if you're looking at from Part 1 arbitration perspective, because it's not only Section 16, because you have thereafter in Section 34 also, you can ventilate your grievance there. And so far as Section 16 is concerned, it pertains to the jurisdiction and validity of the agreement itself, existence or validity of the agreement, arbitration agreement itself. So scope is quite broad. And given the party autonomy and the autonomy, sort of the flexibility of the arbitration process itself, if court tries to exercise jurisdiction despite having an arbitration clause, I think that would not be considered as a pro-arbitration approach. So Section 16 is sort of a rescue to that extent, but you should not read only Section 16. As I said, Section 5 and Section 34 also are helpful to that extent.
Sure. Next question is a little vague, but it's an interesting question. It's for Lomesh. Do you think India is ahead of the international jurisprudence only in relation to anti-arbitration injunction, or there are other arbitration concepts also where India is leading? That's a very interesting question, actually.
Yeah, that's what I call a absolute googly in that sense. So it's a tough one. I mean, to be very honest with you, having seen the arbitration regime grow from time to time, right from the 1996 Act, if you look at the 2015 amendments, if you look at the Law Commission reports that have come, 2019 amendments, I would say in terms of international developments, in spheres other than anti-arbitration injunction, India is still probably sort of catching up with the international market. I would say the international market, particularly advanced jurisdictions like Singapore, have sort of, and Hong Kong also, have taken huge leaps and strides in order to ensure that their countries become extremely pro-arbitration in that sense. India, the problem is, as Justice Nariman also said, it's a case where we tend to go sort of one step forward and again go 2 steps back. And every time there is a new legislation or anything comes, there is either drafting errors that happen, some commas are missed, some basic recommendations of the Law Commission itself is not taken. Of course, those errors to a large extent have got weeded out since 2015. And I would not, had you asked me this question in 2015, I would have said hands down, there is no doubt about it that there is a long, long way for us to go. But in 2019 and 2020, I'm probably a lot more optimistic that at least insofar as the legislative space is concerned, we are much better than what we are. But yes, to answer your question, we still have many more miles to go, so to speak.
Surjendu, your
Sorry. Hello.
Surjendu, we can hear you. Please.
Abishek, did you ask anything?
I asked you your views on this. Your views on this. Is Indian jurisprudence on arbitration ahead of the international curve in any other aspect other than anti-arbitration injunction?
Yeah. From that perspective, I agree with Lomesh. Now, of course, we are trying to improve ourselves, and I'll say that controversy sort of arises because of diverse opinions by different high courts at some extent, by Supreme Court also, which is not following the exact path of the approach in arbitration. So there are issues, but I would say that we have overcome many complications, and we're trying to improve our image. And with this sort of pro-arbitration judgments, Veena Modi, Lalit Modi, Vodafone, so on and so forth, I think we'll be able to improve our image far more better in the coming years.
Sure. Next question is also for Surjendu. You briefly touched upon the topic of jurisdiction, but if you could just give us in 2-3 pointers about which court will actually have the appropriate jurisdiction in case of a anti-arbitration injunction, the seat or any other court with appropriate civil jurisdiction. It's a little general and vague question. Many times. I'm just asking you this. I'm sorry.
No, I actually those two may not match, because you are trying to injunct an arbitration proceeding that may not be necessarily you're filing the proceeding in the place. I think it would be other way around. So you're trying to file some suit, or you file some suit in some other country, not in the place. So once you file in the place, then I think controversy is to some extent narrowed down. So when you file a suit seeking anti-arbitration injunction, if you look at international commercial perspective, then of course it ideally should not be the place of arbitration, and it would be the party's own jurisdiction wherever the cause of action arises. For example, the agreement is entered into in Delhi, so you file in Delhi. You file a suit in Delhi High Court if it is beyond parole. That way, you create a jurisdiction for the suit under CPC. You don't keep in mind, Arbitration Act, because your approach is to stop arbitration. So you keep in mind the CPC and you file the suit. So wherever the cause of action arises, not necessarily where the defendant or the respondent stays. I think that's what I have to say regarding jurisdiction.
Yeah, Abishek, can I also?
Please. I was going to.
So I agree with Surjendu. I would make a distinction again between an action that is taken insofar as an international case restraining, asking for an order of injunction restraining arbitration proceedings versus domestic parties. Now, as Surjendu mentioned, insofar as the international parties are concerned, there is no way an international party, let's say there is an arbitration agreement between a UK party and an Indian party. There is no way that UK party would come to an Indian court to ask for an anti-arbitration injunction. Naturally, he would go to the UK court because he would not want to be submitting to the jurisdiction of the Indian courts whatsoever, because his contention would be that the Indian courts or the Indian arbitral tribunal does not have jurisdiction in any manner. So he would get that adjudicated by the UK court to say that since I'm a resident of UK, applying the principles of whatever the principles of that particular country would be, to say that my rights are getting infringed within your territory, so therefore I'm asking for it. But there is a slightly sort of nuanced argument insofar as the domestic parties are concerned. And I don't know if it has really been tested by the courts in that sense. The reason is there are lots of judgments today. Justice Nariman has passed several judgments also, clarifying that wherever the seat of the arbitration is, that is where you have to ask for all reliefs possible. Now, whether that principle can also be made applicable to anti-arbitration injunction, my response would be that no, it does not apply. But it would be interesting to see that, because if you're an Indian party in that sense, you would still probably be nationally driven to a place that you actually belong to and apply the principles of CTC and then go there. But it's a very sort of, there's an interplay between the judgments of the Supreme Court saying that everything has to happen wherever the seat is versus the appreciation of the CBC principles.
Sure. There is a question by our dear Pratyush Pandey. It is for Surjendu. What is more important for anti-arbitration injunction? Intention of parties to enter into arbitration or existence of a valid arbitration agreement?
Yeah. Intention to arbitrate, I don't think is the only threshold criteria. You have to get into the existence of arbitration agreement. Of course, then what you prove or disprove either way, because the party who is seeking anti-arbitration injunction has to establish that the agreement is inoperative. So arbitration agreement exists. It's not intention, but it cannot be given effect to, or it's null and void for some reason, for fraud, misrepresentation, or some other issues happen. So I think you have to get into it that arbitration agreement exists, but it cannot be given effect to.
Sure. Now, this is a question I would like both the panelists to speak on. This is a very straightforward and frank question. Isn't Bina Modi too rigid and fails to maintain the flexibility between courts and arbitration panel? As in, for instance, in a situation where court can actually give a time-efficient remedy and close the matter right then, it would refuse to exercise jurisdiction and refer it to a arbitration panel. So the time efficiency might also be a factor here. So do you think it's too rigid? In order to become pro-arbitration, we have completely divested the courts of the jurisdiction. Surjendu, please.
Yeah. So, see, I think it's the principle of arbitration that's more important, because in terms of rigidity, of course, courts will be more inclined to exercise jurisdiction. In fact, that's what Justice Enlaw also says, that Indian courts specifically, they are just tempted to exercise jurisdiction. But the problem happens once you have an arbitration agreement, the principles of party autonomy and is respecting the party's choice. Once you have entered into an agreement, you should respect that. You should not derogate from that. That's the principle which compels the Indian courts, or it should compel the Indian courts to grant any anti-arbitration injunction.
Lomesh, your views on this?
Yeah, that's an excellent question, Abishek. I must say that that was something that was playing on my mind also to sort of cover in my presentation. In fact, you hit the nail on the head, because that is really going to be an interplay between these two factors in order to see whether this is going to be the law for the future, or is this something that is going to change. My personal view, if you ask me, I think the court should retain some kind of a jurisdiction. And I think the courts have consistently held, even under Indian jurisprudence also, that it should be only in cases of extremely rare and exceptional circumstances that you interfere. And I do agree with the view that you also sort of expressed when you were asking the question, that there should be some flexibility for the parties to actually go to the court to that extent and ask the court itself to decide a particular issue, instead of that getting into an arbitral tribunal. Then the arbitral tribunal says that we have the jurisdiction, and then you say that the moment, even if it is refused, you can always challenge it as part of the arbitral award. So that may actually be a time-consuming process in that sense, which will be subject to numerous appeals, and your basic contention has not even been decided. Let me, however, caveat this by saying that this obviously has to be only in exceptional circumstances, and the court should ensure that they do not sort of step in on every jurisdictional aspect. It is only in cases where it is blatant that there is no arbitration agreement itself, or where it is null or void or inoperative for whatever reasons, which Section 8 and Section 45 clearly says. Only in those situations they have to interfere, and not in other situations.
I have just one point to add. I agree with Lomesh, but there's one aspect what we should keep in mind is that when you're filing for anti-arbitration injunction, is the suit for mandatory injunction you are filing. So your merits are still not decided. So problem happens then once it is decided, no, Indian courts have jurisdiction, you file a fresh suit on merits to get the issues sorted or determined. So I think in terms of timing, that may be more time consuming than referring to arbitration. Just one thought process I had in mind, so I thought I'll share.
I'll just take last two questions and we'll quickly wrap this up.
Sure.
Just take last two small questions and we'll quickly wrap this up. One is a question by Nitansha, and she wants to ask, what are the circumstances where you advise your client to file an anti-arbitration injunction? What would prompt you to advise your client? And Lomesh, we'll start with you.
I think I'll ask Surjendu to go ahead. He's always been the first speaker, so I'll let him give the
There can be exceptions as
first
well.
5 hours on a grassy pitch. Surjendu, go for it.
There can be two situations when you bona fidely believe, you have been on good faith, you believe that you should stop the arbitration, and second thing is that sort of created trouble to stop arbitration. So if you have a genuine reason and you believe that arbitration should be stopped, your grounds will be slightly different and straightforward, because you know that there's a fraud which has been made against you, so you should stop the arbitration. Contrary to that, if you're trying to sort of tamper with arbitration proceedings, then you create grounds, and there's no dearth of grounds as such. I also experienced that other side is making grounds which is not even feasible, not even contemplated by any of the courts. So, depends on the facts and circumstances.
Umesh, before you answer, I just wanted to understand, how do you balance good faith with a strategy to delay the arbitration? How do you balance that?
See, as a lawyer, it's really our job to look out for the best interest of the client. And I do understand the good faith argument, but that is a good faith argument, I guess, would be something that is between you and the court, because you never mislead the court on anything. But if strategically, if something benefits you, and if delay is part of the strategy, I mean, let's all admit it. All lawyers do it. And strategically, if you want the other side to come around for a settlement, sometimes delay is also a tactic. And these are all sort of acceptable truths in that sense. Now, coming to the question, with your permission, if I can answer the question. The question asked was, what are the circumstances? Of course, as Surjendu said, there'll be multiple circumstances under which you can file it. But really, in terms of the law and what the case laws have held, some of the circumstances under which you can really ask for an anti-arbitration injunction are if you are not a party to an arbitration agreement, that the UK courts have very clearly held it. And the Indian courts also, chloro-control, of course, laid down the test. But other than the non-chloro-control situations, you would have an argument to say that prima facie there is not even an arbitration agreement. Secondly, there are also cases where the foreign courts have decided to sort of go ahead and give an anti-arbitration injunction in cases where there was some kind of a fraud involved, where there was some kind of forgery involved. That is probably in cases of the UK courts. There were some judgments like Alden, etc. Whereas the Singapore courts have taken a slightly different approach, where they say that even if there's forgery, etc., nothing doing, prima facie, I'll see whether there's an arbitration agreement, and I'll go ahead with it. The third circumstance would be in cases of where there is no arbitration agreement at all. That would be in cases where, suppose there is a novation of an agreement, or whether there is a superstition of an agreement, where a particular agreement which has an arbitration clause gets completely novated into another agreement which does not have an arbitration clause. I mean, these are classic examples where you would be in a position to make a very strong case for your client to say that the arbitration proceedings that have been initiated by the other party is wholly without jurisdiction in that sense. I mean, these are just some of the instances from analysis of the case laws. And the other instance also would be where a particular court is given an exclusive jurisdiction, like the UK judgment that I referred to. UK courts had the exclusive jurisdiction. They said, since UK court has a jurisdiction, it will trump all other jurisdictions across the world.
Now we'll take the last question, and that is for you, Lomesh. In regards to the sovereign immunity, now we are reading news that there will be a lot of defaults by countries under the One Belt, One Road regime. Nigeria has indicated its failure, that its apparent failure to pay the loans. Sri Lanka is not very happy with the loans given by China, and all these countries have either given sovereign guarantees and sovereign bonds. In fact, one or two agreements also have an arbitration clause with the SCO. Now, do you see sovereign immunity being used by these countries to get injunction on these arbitrations seated in China? Do you think sovereign immunity will be used as a tool to get anti-arbitration injunctions?
Oh, that's a great question, Abhishek. There are two ways to answer this. One, as I mentioned earlier, the United Nations Convention that's still not come into force. So the moment that comes into force, there is a completely different argument that you will take insofar as this is concerned. The second thing is the way you look at immunity is really to look at the state laws of that particular state, whether that state has any kind of a domestic law which prohibits a foreign party from taking any kind of an action. Honestly, I do not know if China has any such law. I'm not aware of it, but I do know that UK, for instance, has this. US, to some extent, has this as well. And it's only when the state has made a domestic law to this effect, stating that there is some kind of an immunity to that state from prosecution abroad. I do not see its application universally as such, and independent of any sort of United Nations convention or a domestic law to that effect. I don't think a sovereign state can wriggle out of its contractual obligations.
Sure. Any last comments by either of you, and before I wrap it up?
I mean, the only comment I have is, of course, the Bina Modi judgment is an interesting development insofar as the Indian jurisprudence is concerned. Of course, the three-judge bench of Quanner cementation is a two-page judgment, so to speak. It'll be interesting to see how the Supreme Court actually views the interplay between the Quanner, the Modi judgment versus the line of judgments that have come between 2012 to 2020 to see what is going to be the future. Whether it is going to be a case where the courts are just going to lift their hands up and say, please go before the arbitral tribunal, we are not going to look at anything, or whether they will really sort of have a cautious approach and exercise jurisdiction in a restricted manner, applying the principles of this rare test. That is something that only the future will tell. But like, just as a last word, arbitration is always an interesting practice in India, and it always keeps us arbitration practitioners on our toes, because pretty much on a daily basis you come up with new judgments, and it will be really interesting to see how this aspect is decided by the Supreme Court.
Considerably, this has been a very slow year for us, honestly, because of COVID. It has been a very slow year for us. With this, I'll take your liberty to close this. Thank you so much, Lomesh. Thank you so much, Surjendu, for this excellent discussion.
Thank you.
Now I'll
Thank you.
Mr. Kundu to close the session. Thank you so much, sir, for having us. It was a pleasure to moderate this session and have this session with you excellent practitioners. I hope to be in touch and discuss the Supreme Court ruling on this aspect soon. Let's see.
Absolutely, we should. And thank you so much for the opportunity. Thank you very much.
Yes. Yes. Thank you so much, Mr. Surjendu, Mr. Lomesh, and Abishek, for this insightful discussion on this such an important issue, that is anti-arbitration injunction. We look forward to your cooperation in near future also. You would be planning to organize this kind of webinar, and we would be looking forward for your help. Thanks a lot from Dr. Ramono Lohiya National University. It was a pleasure meeting you. Thank you.
Thank you, sir. Thank you. Thank you very much. Thank you, Abhishek.